David Berkowitz, the son of Sam, Indictment, Kings County. This presentation is for educational purposes and is being presented for the historical record. The Brooklyn legal proceedings against David Berkowitz stem from the final shooting in his citywide attack campaign. On July 31st, 1977, Stacy Moskowitz, 19, and Robert Violante, 20, were shot while sitting in a parked car near Shore Parkway and Bay 16th Street in Bensonhurst, Brooklyn. Moskowitz died from her injuries 18 hours later. Violante survived with permanent loss of sight in his left eye and severe impairment in his right. Following Berkowitz's arrest on August 10, 1977, a Kings County Supreme Court grand jury returned an indictment charging him with the Brooklyn assault and homicide. The actual docket is quite short, so I'm going to go ahead and read it to you, and then at the end I will explain the charges in case you have questions. Supreme Court of the State of New York, County of Kings. The people of the state of New York against David Berkowitz. Indictment number 2673, 1977. Counts: murder in the second degree, attempted murder in the second degree, assault in the first degree, criminal possession of a weapon in the second degree. First count. The grand jury of the County of Kings, by this indictment, accused the defendant of the crime of murder in the second degree committed as follows. The defendant, on or about July 31st, 1977, in the County of Kings, with intent to cause the death of Stacy Moskowitz, caused the death of Stacy Moskowitz by shooting her with a loaded firearm, thereby inflicting divers wounds and injuries upon Stacy Moskowitz, and thereafter, and on or about August 1st, 1977, the said Stacy Moskowitz died of said wounds and injuries. Second count. The grand jury of the County of Kings, by this indictment, accused the defendant of the crime of attempted murder in the second degree committed as follows. The defendant, on or about July 31st, 1977, in the County of Kings, with intent to cause the death of Robert Violante, attempted to cause the death of Robert Violante by means of a deadly weapon. Third count. The grand jury of the County of Kings, by this indictment, accused the defendant of the crime of assault in the first degree committed as follows. The defendant, on or about July 31st, 1977, in the County of Kings, with intent to cause serious physical injury to Robert Violante, caused such injury to Robert Violante by means of a deadly weapon. Fourth count. The grand jury of the County of Kings, by this indictment, accused the defendant of the crime of criminal possession of a weapon in the second degree committed as follows. The defendant, on or about July 31st, 1977, in the County of Kings, knowingly and unlawfully possessed a loaded firearm, to wit, a revolver, with intent to use unlawfully against another. And this is signed Eugene Gold, District Attorney. Now a brief explanation of the charges. We'll start with Stacy Moskowitz, murder in the second degree. Why in the second degree and not the first? Well, first-degree murder, which was Penal Code 125.27, was strictly reserved for specific aggravating factors, such as killing police officers, judges, or witnesses, which was not the case here. Attempted murder in the second degree for Robert Violante. This is applied because Berkowitz fired directly into the vehicle with the intent to kill both occupants. Under New York Penal Law 110.00, an attempt occurs when a person engages in conduct that tends to affect the commission of the intended crime, even if the victim survives. Assault in the first degree. This is also for Robert Violante. Charged as a top-tier violent felony because the act caused serious physical and permanent injury, blindness, and facial trauma by means of a deadly weapon, .44 caliber revolver. Prosecutors routinely include both attempted murder, focusing on intent to kill, and assault in the first degree, focusing on execution of severe injury to cover all statutory theories of harm before a jury. Criminal possession of a weapon in the second degree. Under New York Penal Law 265.03, carrying a loaded firearm outside one's home or business with the intent to use it unlawfully against another constitutes second-degree weapon possession. Under New York statutes, this was the highest felony charge available for possessing a single handgun with unlawful intent. First-degree possession was reserved for mass arsenals or explosive materials. This concludes the presentation on the indictment proceedings. Thank you so much for listening.